Yeah, please, Manoj. As promised, Manoj, not more than 5 minutes I'll take, and all these 18 matters can be disposed of. If I can just explain in 2 minutes what was the grievance in the petition, Manoj.
No, no, that's I've understood.
With this division bench's order, Manoj, the grievance stands satisfied. Therefore, Manoj, the suggestion that I'm making for my Lord's kind consideration is after division bench.
No, we'll not go into now. Yes, Mr. Majumdar.
My Lord, yes.
You have said that the petitioner is being considered. Their verification has been taken.
Yes, we are undergoing to
So
take
if
verification.
you are allowing them, what's the use of?
No, my lord, they whether they are to be considered for appointment or not on the basis of the orders, because the first sentence that I found in the writ petition was they are relying on judgments of the Honorable Supreme Court saying that this is the review order, this is the orders passed. Their writ petition starts with the sentence saying that the judge's judgment is not applicable to the state of Assam. That judgment, the original judgment, is not applicable to the state of Assam is how they start their writ petition.
No, the answer.
The writ petition.
The writ petitions were filed prior to the clarification order. When the judgment, original judgment came by which they disqualified me, the writ petitions were filed after that. Thereafter, during the pendency of these writ petitions, the Honorable Supreme Court on 10th December 24 has clarified that what my original order was not to devalidate or de-recognize the course. And after 10th December, 4 times, even 2 days back for state of West Bengal, they have passed a judgment, Honorable Supreme Court, where they have said that both these courses,
Then why don't you approach the Supreme Court?
Well, the reason that is this. All those states, West Bengal, Bihar, Uttarakhand, etc., the high courts had given a judgment prior to the clarification and against us. Now, this is the only state, Manoj, in my humble submission, where the matter is sub judice when the clarification has come. So, therefore, all those states, which in fact, some of the states I had the opportunity to represent, we challenged the High Court's judgment holding against us, saying that they are misconstruing Honorable Supreme Court's order. So, therefore, the Honorable Supreme Court has set aside all of them, saying that West Bengal, Bihar, Uttarakhand, whichever went there, whatever the High Court has held was is erroneous, is what the Honorable Supreme Court says. And finally, what they have said is that both these groups, that is 24 months vis-a-vis 18 months, are at par with each other. In fact, here in Assam, we are at a better position because there is no appointment. Wherever there was appointment,
wrongly or rightly,
Lord,
they have debarred you and they made you ineligible.
Indeed, Lord.
Because of 18 months.
Indeed.
Right, 18 months, right?
Yes, the state made.
So why don't you approach the Supreme Court?
The answer to that is this, Lords. Once they debarred me, they passed a circular on 2nd January 24, relying upon the Honorable Supreme Court's order. That circular is the subject matter of this writ petition, where I am seeking a quashing of that circular. During the pendency of that writ petition, the clarification has come. Now, for any reason, my lords, if my lord had to, of course, now there are 3 orders which they are bound to follow. It is an Honorable Supreme Court's order. If for any reason this writ petition is not allowed, saying that yes, the 2nd January circular, yes,
they have relied on the Supreme Court judgment.
Subsequently, it has been clarified, which they have not taken.
Then you approve the Supreme Court.
The answer to that is this. If it has been clarified subsequently for whichever there was a negative order, my lords, before the Honorable Supreme Court, and that is, if I can just show that for three states, I will take one minute each. The problem is this, my lords. Now they have given a concession before the Honorable Division Bench, saying that I will be considered. If I will be considered, the 2nd January 24 notification, which is the subject matter of this petition, has to go, because that is the only hurdle. That's point number 1. They also gave a statement before the Honorable Division Bench that I'll be considered for the present 26th December 2023 advertisements. My second grievance in the writ petition also stands satisfied. So all that I'm seeking is that on the basis of those 2 statements given by them before the Honorable Division Bench, the writ petition may be allowed. That's point number 2. These are the 2 points. There is also a third point. The third point is this, that all these 4 judgments that have been passed by the Honorable Supreme Court in Bihar, Uttarakhand and West Bengal, laying down the same principle, they have extended the benefit of consideration only to the petitioners / appellants before the Honorable Supreme. So therefore, the third request that I'm placing for my Lord's kind consideration is that the writ petitioners before my Lords are about 1,700 in total. So the consideration by them for this recruitment of 26 December 2023 should be only restricted to these petitioners as laid down by the Honorable Supreme Court in those 3 matters. Now, for me to go there, my lords, I need a negative order. And any person approaching the court, my lord, would believe that we'll get a positive order before this court. Specifically, my lords, when those orders were passed there was no clarification. Hence, the Honorable High Courts in various states followed Javeer Singh and said that they are not eligible. But once we went there and we said that, yes, this is.
That's why you go again here.
My lords, by that time, can I just show that these two orders, maximum 1 minute, it will be completely clear. Can I just show those two orders?
I'm clear.
My lord.
Why I'm not clear is why you are not approaching this.
My lord, we don't have a reason to go there for now because the matter is sub judice before my lords, and my lord's kind indulgence on the last hearing.
We'll grant you a liberty, close the matter, with
Can
the
I-
liberty to approach the Honorable Supreme
If my lord can just have.
because the matter has been decided by the Honorable Supreme Court and it has been clarified. Why don't we approach this?
My lord would just have one order with me for a minute. In fact, my lord would just have an order of passed by this honorable court on 10th February 25. 10th February 25 in this batch of writ petition, there is an order passed. The order simpliciter says, I will not trouble my laws to go through it.
No, read it.
Yes. My lord, this order says, the petitioners, by way of instituting these batch of writ petitions, have raised the grievance with regard to the prescription of qualification in the advertisement dated so and so. The fundamental ground of the petitioners is that in terms of the determination made by the Honorable Apex Court in order dated 10/12/2024, passed in review petition so and so, arising out of so and so, the petitioner's qualification of DLED is being recognized. That is the grievance that is recorded. It is further contended by the Learned Counsel for Petitioners, that is us, in terms of the aforesaid determination made by the Honorable Apex Court, the competent statutory authority NCT has also recognized such qualification which is acquired between 22/9/2017 to 31st March 2019. And accordingly, a notification has been issued. It is further the case of the petitioners that they have acquired their qualification during the aforesaid period and therefore their candidature should be considered by the selection committee. Mr. So-and-so, Learner Standing Counsel for the Education Department, Assam, submits that they may be allowed some time to respond to such contention. So therefore, and finally, these matters were to be listed on 18th March. So therefore, an IA was filed that now once the Honorable Supreme Court has given a blanket order saying that every state needs to comply with my clarification, why is the state of Assam not complying when state of Meghalaya has done it? All other states have done it. It is only state of Assam not doing it. So therefore, an IA was filed here. On that IA, this order is passed, saying that once there is a clarification which is blanket, which is not specific to one state, you should please apply the clarification and the basis of which your circular was issued. So the circular of 2nd January 24, which is impugned, is only on the basis of Honorable Supreme Court's order. There is no other basis. So therefore, what was argued
According to you, that has been subsequently
clarified. And that has been clarified.
After the issuance of this.
Indeed. This advertisement is of December
After
20.
the issuance, before the issuance of clarification,
My lord.
they have issued the impugned circular.
Indeed. My lord. Indeed. The impugned circular is prior.
They filed the affidavit.
They have not filed an affidavit, but my lord, with these three judgments, I would submit, and therefore I am taking this.
No, I've understood. We'll go at this. Without their affidavit, how can we dispose of the matter?
I understand. My lord, their concession is recorded.
I've heard you. We'll listen. We'll hear him.
Yes.
Whatever he said. Yes.
Lord, on the last order that was passed by lordships, I was required to be given the copies of the writ petition and all, not served to me as of today by that one.
I'm sorry.
Now,
We
with that
know, we
affidavit,
have fixed the
therefore,
matter. You have approached the division.
we approached
President Bench
only,
also fixed the matter.
only thing that we received, only thing that was there before the appellate court, the
No,
appellate,
forget about it.
no, there,
What,
we
what,
only,
what is your response?
we only.
Okay,
could
we'll
not-
give you a time to respond, file an affidavit, but then what do his response?
My lord, our
The
response,
impugn order
they
has been
start-
issued. No, impugn order has been issued before the clarification issued by the Supreme Court.
the clarification, the first clarification came on 10th of December, if I'm not wrong.
Yes.
Our office memorandum was issued on January. So it was after the first clarification.
No.
It
January
started.
24. I'm sorry. January 24.
Just
is-
wait, we'll hear you.
That is what that is what I remember the cases. Now, when they challenged that particular office memorandum, the first thing that they said was JV is not applicable to us. They start the writ petition saying JV is not applicable to us. The Supreme Court orders are not applicable to the state of Assam. So therefore, the office memorandum should go. Now there is a complete change saying that no, any clarification given in that case has to be applicable to us. What do I answer to me?
No. Actually, accordingly, you answered.
And
to
now, my lord, now the
you say if it is not applicable, you said once you have said that it's not applicable. Matter ends there. Now we'll consider it, we'll determine it. Now they are saying that because after the subsequent, I mean, whatever
yes,
clarification, it applies. What do you say on that?
the Supreme Court has clarified that 18 months DLED course will be equivalent to the 2 years DLED course. But still, in my humble submission, the state government has the right to find out which of the equivalent qualifications we need to choose for our selection.
No, nobody is objecting that you can, I mean.
So therefore,
you
we
can-
choose the 2 years, even then the 18 months goes. If we are choosing the 2 years, which is
No,
for our roots.
nobody is questioning your, the choosing whatever you choose, whatever
Yes.
your authority to decide
Yes.
what qualification, how
True.
how much, what would be the qualification for a particular post. Why not on that? Today we're on that after the judgment clarification of the Supreme Court.
My lord.
What would you say? Whether
We are
it
saying
applies
that-
to your state or not?
My lord,
If you, whether it applies to the state of Assam or not?
the judgments.
Yes,
If a certificate is equivalent, it is equivalent.
yes.
The Supreme Court says
So,
it is
you
equivalent.
cannot
it is
have
equivalent.
it. You cannot just
But
because
then-
no.
but
just,
then whether
just
we
because,
need-
just because you have the authority to decide
Yes.
what would be the qualification,
Yes.
you just cannot decide. Contrary to the what is
So that is why
passed by the court.
we would have to file our
have-
affidavit in the different cases, in all the cases, because there are two batches now I see. One batch which says that it applies, one batch says it does not apply. I do not have copies. I can start reading the first line.
No, let us not
Lord,
go
we will
into
find
that.
the
Let us not
first-
go into the technicalities of the pleadings. But
The exact
it's a
reading,
reference- no.
reading is sacrosanct, my lord.
no, these are the only sacrosanct. I understand, but the nature of the case we're dealing with, it's a simple matter. Why are you making it complicated? If you agree that on legally, when the Supreme Court decision is something different which cannot be made applicable in a state, you argue that.
That is what we would like to argue with our affidavit, my lord.
You just cannot have that kind of.
When Lordship should give me a week's more time, asking them to give me the copy. We'll have it immediately on the reopening, or we'll have it on Friday.
No.
I'll still try to
These
draft it up.
These are recruitment process
Oh,
just
it-
because that day you want to hear you argue the matter. I remember
Yes. And I had also made a
because you
statement
had
my
an
lord, that
apprehension that the process will be staged.
stalled. Yes. The process is not stalled.
No,
The
it's not.
process, the process. is
Now,
not-
when he made a mention this morning, I said, I'll not hear the matter. If it will take, detailed hearing,
My lord,
if that is your stand.
my lord.
But then he said, division bench is fixing the matter today.
No, division bench has said that the matter would remain fixed today. There is no
And
difficulty on that.
the division bench interfered
Division
with
bench has-
the interim order just because of your own statement,
No,
saying
division,
that they are being considered.
we are, my lord,
They are
we are,
not
we are not, there was no statement made that.
Now,
because
issue
the Constitution
issue
find the
is
order.
the office memorandum is in consonance of the decision of the
May-
Supreme Court or not. That is what.
May I just state, my lord, what was said to the honorable division bench? We said that since they have applied, all applicants who have applied under the advertisement, we are going for a physical verification of all of
That's
them.
fair enough. Fair
So
enough.
there, but as of now, the documents are being physically verified, there is no difficulty.
Yes.
But that is not the end to their problems or to our problems.
No, that's why if you are objecting, we'll hear you.
That
We
is what I was-
don't, since you have allowed them and you have, as the impression was made by
That-
the
that
learned
interim
counsel for the
So far
petitioner
as the
that,
interlocutory,
since the petitioners have been
so
allowed.
far as the interlocutory applications are concerned, my lord, they are now set at rest because we have allowed them, we have called them for the, we made a concession that we call them for their physical verification along with all other people. Any and everybody who has applied, who comes within that particular 1:2 or 1:5 zone, everybody comes to get their physical documents
Have you gone
verified.
to the judgment of Supreme Court?
Which one?
Which is reliant.
Today morning, I was given a copy when I was in court number 4. I think I left it there itself. Yes, I left it there. I'm sorry, but there was a bunch of judgments which are
Decide it. Forget about what is the whether you have correctly issued an impute notice or not.
My lord.
Impute notification or not. Maybe state might have at point of time may not have looked into it. It's you to tell them. If you legally, if it is contrary, I mean, as per the, if you have issued it, I mean,
With
use
the
your
orders,
office.
with the orders
I would
passed.
request the Advocate General and you also to use your office, good office.
Could I pray, my lord, the matter be taken up
Not
in
with
the
a heck
immediately?
of- See, we don't expect. I mean, maybe there may be a wrong interpretation, maybe to this court also.
I could be wrong also, my lord.
We do do the best of our
Yes.
knowledge only. So go for that. Let us not go into that whether once the state has issued an order, will stick to, will have to defend it.
Not
There are
this.
cases which may not be, which may be
It may not be a
indefensible.
But
May
that
be
is,
indefensible.
but that
Then
is,
the way out is to advise the government.
would lordships.
And I understand, I had the experience. They always stick to their order, no matter how it is. You'll ask, they'll ask you to go to the Supreme Court also. If possible, International Court of Justice. If it lies. But then we'll have to
Because
advise them. I have not gone into, I have not, but prima facie, I see that there is something
And-
contrary.
our first opinion, which went in this case, when the first
And
time the
see,
matter came up,
number two,
prior to Javid,
even
Javid,
for,
it was-
even for a moment, I'm not saying that you don't have an authority to decide
Yes.
what qualification would be required for the particular. But problem here is not that. The issue. Issue is whether your notification debarring or
Needs a-
making them ineligible
needs a little.
is consonance with the decision or of the Supreme Court or it is contrary. That's all.
But it-
You go to the Supreme Court judgment and the clarification thereafter, whatever is there, and then look into your office memorandum.
May I pray, my lord, the matter be taken up on immediately on the reopening on the first or second day. There is no difficulty. I'll have a consultation with the learned AG also. We'll try to have the department concerned. We'll have a discussion. Lordship will have it
This
immediately on the reopening.
Seriously
by-
feel
because
that
by-
way the things can be resolved
Yes.
without having a kind of difficult adversarial form of litigation. We should resolve it.
This is
See, tomorrow, if we find that this is something wrong, we are not here to confront with anybody.
no.
Where all of us,
never.
including you and us, we all are here for justice
Indeed.
to the best of our knowledge and ability. We are not against anybody.
We cannot. That is never, my lord. What
The litigants before us is not only the petitioner. The government and the respondents are equally the litigants. So there cannot be any, I mean, kind of thing. that's-
the
In fact,
intention
when the
of the
clarification order was given by the Honorable Supreme
So
Court.
in any case, Mr.
Mr. Kalra.
Huh?
Mr.
Kalra.
Kalra.
We'll fix some other day. In any case,
Because I understand what it's doing. Just consider me
we
for
thought, I have indicated you if it requires, I'm not averse to, I mean, detail hearing.
I understand.
But then problem is, they have not filed the affidavit, let them file the affidavit.
let it be immediately on
Maybe
the
your petition is bulky because there are so many petitioners.
I understand.
But the issue is very simple.
issue is simple.
In
That
fact,
is-
Manoj, if I can just add, just to
I'm not saying that what
Kidding.
they should decide, what I,
no, I understand, Manoj, but with due
24th
respect, my lords, kindly consider this.
24th or 29th.
The authority,
rather I'm asking that assistance from them,
indeed, my lords,
including you.
but kindly consider this submission for 1 second, my lord. The authority to fix the minimum qualification for primary teachers. I'm conscious of the time, my lords. I'll not take more than 1 minute
No,
as
no, no,
promised.
you are free.
My lords. The authority to fix the minimum qualification for primary teachers in any state is NCT. The NCT has recognized my course.
Having
Yeah.
that
Where is
background
it?
only,
Yes, my lord.
having
That is
that-
point number 1.
considering and keeping that in mind,
That is point number 1.
in the background, I'm
Indeed.
deliberating with you.
Point number 2, when the clarificatory order came on 10th December 24, the notification is of 2nd January 24. 11 months prior to the clarificatory order. The clarificatory order comes later, but makes it applicable from 28/11/23. So prior to the notification, the clarificatory order is made applicable by the Honorable Supreme Court. State of Assam is a party there. I filed an application on behalf of some of the applicants
Then
here.
I've heard you. You have
Yes, my lord. So State of Assam is a party there.
other day.
Indeed, my lord. I'm so
Okay,
grateful.
thank you.
Number 3,
So you
just
just
one
tell
last
us
thing.
when to.
Just one last
After
thing.
3 weeks.
Just one last thing.
You have been allowed, all of petitioners have been allowed
My lord,
to participate
that may be recorded. my lord.
by verification.
That may be recorded, my lord. All
Not
petitioners.
recorded, that's already clear. Right?
My lord,
By the division bench. Why
therein
should
they
you-
have said that respondents therein, they challenged only
Why
one.
just granting them few days, few weeks time to, or 2 weeks or 3 weeks time to file their affidavit, will dispose of the matter.
My lord, but the petitioners, that may be recorded that petitioners are allowed for the verification.
No, division bench.
All
they
the-
will
they-
state-
they-
no, no,
the
in
division-
the basis of the statement of the Advocate General,
All
Learned Advocate
advocates.
General. The division bench has
My lord,
passed the order.
yes,
So
in the
we
division
cannot-
bench's order, they have said respondents herein. So the respondents there were only 40. So therefore, my lord, it shouldn't be. And all these orders that
No,
I
no, that
wanted-
we cannot, I cannot modify the
No,
order of
I'm
the
only on this
division
point.
bench.
what the Honorable Supreme Court has said,
Sorry,
that only the
we'll see,
petition.
we'll see.
My lord, just one.
Our issue is now
Please.
whether, as per the Supreme Court clarification or the judgment,
Please.
whether you are eligible
Please.
for this post,
Please.
whether the notification is contrary or in
Indeed.
to the
For
decision.
that,
That's
just
all.
wait
That's
for 10 seconds. See these two orders of the Honorable
No,
Supreme Court.
you
Recent.
said
Well, it's
Yes.
recent most. It will cut the controversy
have
short. That is
corrected
the.
time. All
It will
right.
cut the. Just see for a minute for my satisfaction.
It's
Lords
okay.
may not.
No, no.
Kindly see for a minute.
I have indicated you
My lord.
in the morning
Well,
itself.
Indeed,
that
I agree to that.
either-
My lord, then
either
that's
will
why I'm not
take
taking.
up take up the matter or not.
I won't take more than that time. Just
No,
see.
it's okay.
Well, just see
Sir,
for one
Mr.
minute.
Kalra will decide the matter finally.
Only
Let
for
me
my,
file the affidavit.
only for my this one. Only for my satisfaction. But only for my satisfaction. Just one line from the Honorable Supreme Court's order. One
It's
line.
okay. It's okay. We'll consider everything.
My lord, then at least.
We'll
At
consider
I
everything.
understand. At
Ah.
least the petitioners may be considered for verification, my lord, because it shouldn't be. And
No, no, that's already supreme.
there is an
the
apprehension.
Advocate General has already.
There is an
Advocate General
apprehension.
has already made the statement
Yes, there is an
before the
apprehension.
division bench.
Yes, there is an apprehension. The apprehension is this.
You come back.
These three orders, my lord, of the Honorable Supreme Court, they have categorically written in 2 lines that only the parties before this court will be considered. They have written that. Now, my lords, while considering,
Are you aggrieved by that?
I'm not aggrieved by that. I am saying the parties herein may be considered. That's all I'm saying.
No, no.
It shouldn't be. that-
Judgment
If you are aggrieved by the decision of the order of the division bench, you approach the.
No, I'm not
appropriate
agreeing, my
forum.
lords, but again, because they are
Then-
taking,
How can I pass an order over and above the division?
it is
bench?
not over and above that, my lords. They, before the division bench said that we will be considered. Now they are saying that whether we are eligible or not, we'll decide later, my lords. The question that I put to myself is, what is this happening?
No, no, no.
Before the
See,
division
see,
bench, they said we'll
Reason
be
is,
considered.
sir, reason is very simple.
I'm sorry, my lord.
The interlocutory application was against the verification stage.
Indeed, my lord.
So this court has still returnable that, considering that matter will be taken up today. I said, don't do
Indeed.
that next one, because it's yet to start. But they filed an appeal before the division bench. The Learned Advocate General has said the cases of the petitioners, whoever, the parties are being considered, their documents are being, they are
Verified.
also, their verification process, their cases also been taken care. On that ground, a decision has been said.
Indeed,
Right.
only on their concession, not on merit.
So now they are doing it.
Yes.
They'll be doing it.
Okay.
Now, issue would be,
Please.
the main writ petition would be whether the impugn notification making you ineligible or
Please.
debarring you for having that thing, whether it is legal or not, we'll see, or it is in consonance or contrary to the.
Very well. This is the last thing.
So here, your eligibility
My lord.
urgent today has not been decided. That is the subject matter here. The interim stage, the interim stage, the verification, they have sought for it, they are doing it, you have been allowed to go. They said you will be allowed.
Very well. Then
Matter
only
is
this
set
one
now.
additional
So
request.
nothing more.
Yes, yes. The verification for us before the next hearing may be completed. At least that
Okay.
much
No,
of
that we
request.
cannot.
My lord, then it will just go it will just go on and on and on. My lord may give a date of their choice. give a date of their choice, my lord. By that time, at least verification.
We don't have to say.
My lord, it cannot be a never-ending process, my lord. I'm
Everything
sorry,
in
my
the
lord.
No, that's not the never.
My lord, for the others,
You
we
are
completed
always
it in 10
open.
days.
You are always the doors are open for everybody.
My lord,
to
I
come
understand,
back
my lord.
if there's
But
a- if
it
you are
can't be a
agreed.
never-ending process, my lord. Then it
No,
is
it's
their
not a
case
question
that
of
it is
never
not
ending.
covered.
No,
And
they'll
sorry,
stick to what they have stated before they.
my lord, but there has to be some deadline to it, my lord. I am not asking for modification. I understand, my lord, but there can be some additional condition because the writ petition is pending here.
No. You are asking me this court to pass an order over and above the.
No, I'm
order of
sorry,
the
my lord.
division
That is
bench.
the impression I must clarify.
akin to
I must
it
clarify.
amounts to that.
No, I am
Which,
clarifying.
which I never expect from you.
I understand. I must clarify, my lord. That is not the impression.
Sorry.
The only thing is,
Okay, thank you. We'll fix that. We're giving them a time to disclaim it. No, I think everything you have been for a time being, you are also safe.
yes, ma'am.
Your
I
case has been
I
considered.
understand.
What's here?
At least on whenever they are filing,
You will
their-
finally decide whether you are eligible or not.
yes, whenever they are considering, my lord, these three judgments may be taken into account. I've already served them.
If you have served, it's okay. If you don't,
My lords, I don't
it's
because
okay.
on February
That's why I
25,
said I expect the assistance from not
We
only
understand.
assistance,
therefore,
better assistance from you all. That's all.
because in February 25 also they said we'll consider
Okay,
it.
thank you.
We'll
Heard,
come-
Mr. Kalra. Lenin. Counsel for the petitioner. And
H. Guwahati,
you are also for petition.
for petitioner.
Mr. Kalra. And Mr. Lenin, counsel for the petitioner. Why this is will release from part hard? Why this is part hard?
Because it was heard in part. There are two orders which my lord had said that will be considered as a partner because my lord had understood the issue fair and square, my lord.
No, no. Do you think that some other judges will not understand?
No, my lord.
Then,
My lord, we'll pray, my lord, if my lord.
and also have Mr.
keep it as a
Majumdar,
partner
Learned
only.
Council for the Learned Standing Council. Education,
Department of School Education.
Department of School Education. And who else? Sir? For
NCT.
Okay. So what is you also assist us, please.
Well.
Look into those judgment. If you don't have, you furnish everyone, share your copy, everyone,
Yes, can you
all
keep
the
one
all
for
the
the
lawyers.
in the court file.
Uh,
These are all three lords, Uttarakhand, Bihar, and
okay,
West Bengal.
on the prayer of next prayer. Learn
Yes,
Council,
sir.
learn Standing Council, Mr. R. Majumdar and Mr. Ayala. Ayala. NCT. Record all the. Let this matter be listed after 3 weeks. Listed. In the meantime, the respondents to file their response. 3 weeks, you file before the next
I'll do
day. All right.
Because may not release it from part or not.
You
That is-
never know. We don't know our.
My lord, we'll try our luck, my lord. We'll try our luck.
No, no, it's not a question of.
I know that. But virtually we can have it. My lord, it's a humble request if my lord may not release it from part. It's only because of.
No, no. Why I'm asking why this has been kept part of.
My lord, because it was heard twice.
Let us see the last.
Yes, the last two orders, my lords. In order prior to that, my lord would see.
In fact, we wanted to dispose of the matter.
Indeed, my lord,
Yes,
indeed.
that's the reason I think.
And therefore, I was trying to trouble my lords with those three judgments. Because
We're
of
not
those
happy.
three judgment, nothing would be left, my lords.
Rather, we're not happy with keeping the matter part hard. It strikes you all the time. It's haunt you. Yes. So should I release Majumdar? Last order is it's kept as part hard.
I would also pray that it be kept part hard because Lordship has gone through it. Lordship, on the next occasion, my lord, we'll finish it. There is an
Will
experience I
you
can.
file it or not? But you will have. to
We'll
file.
argue the matter on the next date.
Okay. This after 2 weeks as part hard.
We'll do it.
Any date may be fixed, my lord. Any date.
You.
29th or 24th?
29.
How about 3 weeks or two?
29.
29th?
29.
29th is fine.
Make it first week. Since you are keeping it part hard,
First.
keeping it
First
part,
May is
Yes,
Since
first
it's a
whatever
part
is
hard,
convenient to-
part hard,
not 29.
First of
After
May.
that, 1st of May, I think.
first May.
I'll be away for the last week. Last week of April, I will be away.
Then
First week of April, May.
first.
Make it on hearing this. On hearing this.
If first is not
Make it Thursday. Huh?
First of May is a Thursday.
1st of May.
first.
Ah.